No. Good morning, Mr. Gill.
Good morning, my lord. The first witness today is Mr. Tony Lenehan, KC, currently the Vice Dean of the Faculty of Advocates.
Good morning, Mr. Lenehan.
My lord.
No, Mr. Gill, when you're ready.
Yes, my lord. Mr. Lenehan's statement, which is available, is the reference is SCIWIT 0649 and then 501. Mr. Lenehan, your full name, please.
It's Anthony James Lenehan.
Yes, and you're a King's Counsel, and your background is, as you tell us in your statement, you were called to the bar, and we'll come to the structure of the Faculty of Advocates in a little, but you were called to the bar as a member of the Faculty of Advocates. In 2005, you became, looking at the date, 2022, did you become a KC or a QC?
It was precisely in the period where I think, very briefly, QC then KC.
Right. And you're currently a KC, and you've been in practice as a member of the Faculty of Advocates from the time you joined in 2005. You were elected by the membership of the Faculty of Advocates as Vice Dean of the Faculty last year, I think. Is that right?
That's right.
And prior to that, you were first Vice President and then President of the Faculty of Advocates Criminal Bar Association.
Correct.
Which is a specialist organization within the Faculty of Advocates representing those who principally practice in the criminal courts.
Exactly so.
Now, bearing in mind that His Lordship and indeed myself are well aware of what the Faculty of Advocates is, there will be people who are viewing this evidence either contemporaneously or in some time in the future who may not be so familiar. So could we just talk a little bit about the Faculty of Advocates? Can you tell us, from your perspective, just a little bit of its history and what it does and what its members provide services in?
Its history is extraordinarily long. 1532, the Faculty of Advocates came into existence. It's an independent referral bar. And so from the criminal perspective, what would happen is that a person accused of a crime would engage a solicitor, and the solicitor would then come to me, and I would provide advice and appear in court.
Yes.
I have rights of audience in all of the courts in Scotland.
Yes. Yes. And I think, as you tell us in your statement in paragraph 5, the purpose is so that the people of Scotland, regardless of wealth, background or location, and also probably of connection, have access to the very best independent and objective legal advice. That's the purpose of the faculty.
And it's a cornerstone of an independent referral bar.
Yeah. Yeah. The Criminal Bar Association, of which you were at the start of the pandemic, I think you were vice president, and then you became president of it during the very early days of the pandemic. Can you just tell us a little bit about that?
The Criminal Bar Association, as you say, is an aggregation of people who have a direct interest in criminal work. It's largely composed of people who are core criminal practitioners. The majority of people, including myself, who do criminal work tend to do very little other than that. It's not easy to run a mixed practice, and it's a means by which representation can be made to the wider world through the media on behalf of this membership, and also discussions and problem solving with judiciary or with the Crown or with SCTS when difficulties arise. It allows people to speak on behalf of the membership.
Right. I think you also tell us that, as well as being principally involved in criminal defence work, and again for sake of clarity, that from your perspective is principally in the High Court.
It is.
You also have a commission as an ad hoc advocate depute, which means that you can prosecute, but I think you've indicated in your statement that it's been some time since you've crossed the room to act as a prosecutor.
Correct.
Just tell us a little bit about your both pre and post pandemic professional life. What's a normal week for you?
A normal week would involve being involved in a trial. Trials in the High Court would normally be 4 days or more in duration. I'll also have to deal with the preparation for oncoming trials. I deal with the preparation for the procedural hearings which take place ahead of trials, and also perhaps sentencing for previous trials. So it involves trips to prison early in the morning. It used to, prior to the pandemic, it would involve meetings in prisons in evenings and weekends, but prisons no longer, I think, are able to accommodate the out-of-hours meetings that took place before the pandemic.
Right. I think one thing I perhaps forgotten to ask you is, and this is applicable to all members of the Faculty of Advocates, members are self-employed sole traders.
Every single person is.
Yeah. And while members of faculty generally operate within either chambers or stables, as they used to be called, for administrative purposes, we are not in partnership with other members of faculty. We are simply, as you say, sole traders.
Yes.
Right. Can I turn, if I may, Mr. Lenehan, to the beginning of the pandemic? Obviously, the pandemic was looming for a number of weeks before lockdown actually occurred in late March 2020. So you, like anyone, would have been aware of what was happening, what was being reported in the news, what information was coming through from Spain and Italy in particular. So all that background would have been, you would have been aware of. Were you engaged in trial work at that time as the world was going through that initial looming process?
Yes, I was in a trial in Glasgow High Court during it.
And can you tell us what happened to that trial?
There was a growing appreciation as the trial went on that this was a more and more important event that was happening. And it reached a stage where we were called into chambers by the judge, and there was a discussion about the fact that it didn't seem as if there was any sense in this going on, and so the trial was deserted. I think about the 20th of March or so. And shortly after that, I think the decision was taken that all ongoing trials had to be abandoned.
And I think in your statement you've told us that from and about that time, in late March, all trials, certainly in the High Court and I think also in other courts, stopped until you tell us about November of that year. So there was that lengthy period of time when trial courts did not operate.
The bracketing of dates, so the trial that I was doing, which stopped, restarted, I've confirmed from my diary entries, on the 2nd of November. So I think that must have been about the first of the trials to recommence.
Okay. Well, thank you for that. Now, paragraph 22 of your statement, you tell us a little bit about the situation pre-pandemic and the number of high courts, or number of high court trials that would be on average taking place. And I think you indicate that there would be 13 high court sittings at any one time. And they would be principally in Glasgow or Edinburgh, but I think also the High Court sits in other locations, principally in Aberdeen and possibly Dundee. Probably different from when I was involved in the High Court, so there probably are others, but those are the principal ones.
Correct.
And I think what is important, just to contextualize your evidence as we go on, is that the number of personnel involved in a High Court trial is quite considerable, and particularly when one compares it to civil proceedings, which I'm probably more used to, because not only do you have people who are, as it were, officers of the court, so the judge, counsel for the accused, the instructing solicitors, court officials, the accused themselves, and of course there may be multiple accused, so there will be multiple representatives for those accused. And then also there has to be 14 members of a jury.
15.
15.
Yeah.
Thank you. Yes. I don't know where I got that figure from. Apologies. 15 members of a jury. Now, we'll come in due course to alternative arrangements that had to be made, but that is what had to be accommodated in due course in other settings to enable a single court to proceed.
Yes.
I think you left out witnesses.
And witnesses.
Which can in criminal proceedings be fairly voluminous. Varies.
Correct. You would often have a list of witnesses in an indictment with 100 plus witnesses.
They wouldn't all be there every day, but there would be so many every day.
Correct. A lot, yes.
What you tell us in your statement is that this has now increased to 21 courts running concurrently.
Yes, I think that's right.
Which is a considerable increase over what was the pre-pandemic level. Can you tell us what effect that has had on those who practice within the criminal courts in terms of pressure of business and work?
The number of people doing the work at the defence side hasn't really increased. I think very recently there have been increases with a bigger intake of new calls to the faculty, but dealing with 2020, 21, 22, 23, it meant that the same number of people were having to service close to double the amount of trials. And so it meant that you would go from the previous ordinary procedure of I would conduct a trial, speak to a jury, wait for the jury to deliberate, look at the next trial, start the next trial and panel a jury and so on. It became the case that I would have to leave, I would speak to a jury in one case, abandon the part of the trial thereafter with the judge's charge often and the deliberations and leave that to my junior, miss out on the softer part of the process of the next trial, which was empanelling the jury, and go straight into witnesses in that. So you found yourself then running witnesses, speech, non-stop. And there would be occasions where I would have maybe 4 or 5 trials absolutely back to back to back to back like that, without any downtime in between them.
Without prying, Mr. Lenehan, what sort of effect did that have on your personal life?
Well, it intrudes into It just simply removes, for a while, almost all of your spare time. So all of the time that you would have devoted to other interests outside the law, that really wasn't available for you during that.
Right, can I move on to one of the initial proposals made to deal with the lacuna that had been caused by the cessation of court business, and that was, there was a suggestion made that there should be juryless trials. Now, I think we all know that this has been something that has been talked about for a number of years, particularly in certain types of cases. One of the things you mention in relation to juryless trials, Mr. Lenehan, is that there was a comment which you refer to on 2 occasions, which in your statement, which was clearly something that you were conscious of. And this was a comment from a senior member of the judiciary who was reported as saying that practitioners such as yourself, i.e. persons who were in the High Court regularly, should be or could be starved into accepting the principle of juryless trials. Now, can you tell us what your reaction to that, or to learning about that, was?
Well, I thought that was an enormously regrettable comment for a fellow professional to make, because it clearly anticipates that I will be forced, and presumably through the consequences to me and my family, to accept a situation which it was known that people in my situation, in the majority, did not think was the best way forward in the circumstances. So it was very regrettable, I thought.
Yes. And I think lying behind that view that you've just expressed was a view taken by many that the jury is an essential part of the administration of criminal justice in Scotland and should not be forsaken.
Yes, I think that's certainly a view I hold strongly, and I think it is also a majority view of at least the criminal bar.
And you put it in paragraph 26, Mr. Lenehan, that you put it in such serious matters, convenience does not trump public and professional confidence in the trial system, and that's a view that you adhere to.
There is no doubt that a move to juryless trials would have sped things up, so it would have been convenient. But what would have been lost in that transition was far greater, I think, and so I stand by that.
Could I interrupt, please? I'm looking at paragraph 26, Mr. Lenehan, and you state there exactly the evidence you've just given to Mr. Gale's questions. You say there was a comment attributed to a member of the judiciary. Was that a comment made in a public forum or public publication?
No, not as far as I know.
That's all I wanted to know. Thank you.
And I should also say it reached my ears through an intermediary.
Thank you.
One of the resolutions, the principal resolution that was arrived at, is what is referred to as the cinema project. And we have already heard in some of the hearings we've had in this inquiry a little bit about cinema juries. And you tell us that that was initially met with some scepticism by the Lord President, the senior judge in Scotland. But he eventually engaged with it and embraced it. Is that right?
That's my perception, yes.
Yeah. Now, just so that we understand it fully, there was some evidence yesterday that I think maybe indicated a little bit of a misconception about a cinema jury. The jury itself is located in a cinema, so that the 15 members of the jury, I've got the number right this time, 15 members of the jury are in the cinema. They can be spaced apart, and there will be presumably officers of the court there to attend to them as well, but they can observe or could observe social distances for their public duty. But the court itself, well, the cinema would be part of the court itself, where the judge, counsel, witnesses, and the accused, and other court officers, that would be in a separate building, a traditional court building, is that right?
That's exactly right. That carried on as before. It was the jury that were made remote.
Yep. Can I understand what your role was? And of course, this is at a time when you were initially Vice President of the Criminal Bar Association and then President. What was your role in promoting cinema juries? Can you tell us a little about that?
My recollection is that the suggestion came from Ronnie Ranucci, KC, now Lord Ranucci.
Yes.
And he and I worked closely with, it must be said, very motivated and talented delivery staff within Scottish Courts and Tribunal Service. And as they evolved how this would work, the input that they needed from the defence to fine-tune things would come from either Ronnie Ranucci or myself.
Right. Right.
And so, for example, we would have a mock-up of it, and we would run through and we would perform the roles of the lawyers, and we would see how things would work, how we would deal with physical items of evidence, how that would be communicated to the jury. And there was a process of refinement over months before it was in a deliverable state.
Can you recall when it was that cinema juries were first mooted? I mean, I don't need an exact day, but approximately.
It would be within a day or so of the suggestion of a move to juryless trials.
Okay.
It was effectively a direct counter proposal to that suggestion, because at the point of that, we were forewarned, I think, by a day or so that that suggestion was going to be made. And from that point on, set about preparing briefing documents for members of Scottish Parliament, so that when decisions were taken, they had the best understanding of the oppositional view to juryless trials as the way forward. And so that would have been part of the proposals to be looked at as an alternative.
Yeah. As I say, we've heard some evidence, His Lordship has heard some evidence already about juries sitting in cinemas, and without disclosing any view that we might take on it, certainly the evidence that we've heard has been that this innovation was certainly a welcome and I think ultimately successful innovation to deal with the situation of the pandemic. Would you agree with that?
I would agree with that. I thought it was successful.
Yeah.
And I was also impressed by how quickly it was made a reality by the SCTS team.
Yes. And I think throughout, on a number of occasions in your statement, you give praise not only to the SCTS team, but to the Crown, to your defence colleagues, other lawyers involved, and the judiciary in bringing this about.
Yes.
One of the points you do talk about, and I think you've already alluded to this, is in relation to virtual hearings and preliminary hearings. Now, again, both His Lordship and probably less so myself know what a preliminary hearing is in a criminal case. But again, just for the benefit of the public, can you just indicate what a preliminary hearing is?
Once the indictment is served, with the charges on it upon which verdicts will be expected from a jury in due course, the parties convene at a preliminary hearing to tender a plea. Some cases resolve at preliminary hearings with pleas of guilty. If there is a case which requires a trial, then there will be a discussion at that stage of how we approach the treatment of certain vulnerable witnesses. We deal with objections to evidence in advance. We deal with any special measures which are required to accommodate particular accused people. And we should leave the preliminary hearing stage with the case in a state of readiness for trial.
Yes. That would include projection as to how long the trial is likely to last and when it will take place.
Exactly so. So we will have a date for a dedicated floating trial diet ordinarily, and that will have a fixed duration at that stage, so that we build into the court diary that it's a 5, 6, 7, 10-day trial, whatever it might be.
Now, prior to the pandemic, the situation in relation to preliminary hearings was what?
They called in person. Any calling of the indictment in court required the accused person to be present unless there were particular reasons why that was impossible. But it has always been important that accused people see what is happening in their cases in front of them. In the pandemic, it was realised early on that bringing people, and I should also say that Glasgow was the preliminary hearing court, Saltmarket High Court in Glasgow, yes. And it would have meant bringing people from the length and breadth of the land into one place, day after day, different people, so that these hearings could take place. Routinely there might be 8, 10, 12 such hearings in a day, and if there are multiple accused, then you can have 20 plus people coming, plus their solicitors, plus family members, all into the same place. And so it was decided that that made no sense in the public health situation, and so we moved on to the virtual platform of WebEx.
And so far as the accused person being able to attend virtually a preliminary hearing, I think you indicate that it is now standard that the accused person is not in attendance at that preliminary hearing. Is that right?
That's right, but not because they're prohibited.
No.
They would be welcome, and it was part of the model that they, if they chose to do so, could attend, if they're on bail, by going to the viewing point of their solicitor, who comes in by WebEx as well. But my practical experience is that if that has happened at all, it has happened once in the time since 2020. I should also say that currently, if a plea of guilty is to be tendered and accepted, then a preliminary hearing will call in person.
Yes. That system that you're now talking about, preliminary hearings, obviously had its genesis in the events of the pandemic. That has continued since, as I understand it.
It has continued, but with one short break. It was argued, including by myself, that it is an important part of the process and the accused should see it. And so we reverted to in-person hearings briefly, but what became apparent was that with the reduction in spare capacity at the defence bar, we couldn't also man or people a preliminary hearing court. Mm-hmm. It is, if I'm trialling in Dundee or Inverness or Aberdeen or whatever, I can log in at a fixed time for my 10 or 15 minutes worth of preliminary hearing. Without that, I would need somebody to cover for me when I'm almost always in a trial in a working day, and we didn't have enough people to do that. So it remains remote because it is necessary at the moment, but my view is that whilst it's convenient to me, I don't think that is the best way forwards once we return to a situation where we have spare capacity.
Okay. You raised the point a couple of times, and it's perhaps useful just to deal with it now. You've talked about the reduction in capacity within the criminal bar did that come about? Because obviously there's an ongoing renewal of people joining the bar, specializing in criminal work, going on to develop a practice in the criminal courts. Has that ceased, or has that reduced, therefore causing this reduction? And in any way was the pandemic, or did the pandemic have any responsibility for that, in your view?
I don't think the pandemic was a significant component. It was something that was happening in the years before the pandemic. It had become the case that the nature of the job was changing, and that meant that people, some very, very talented people, were keen to expand their career in a different direction, most often towards a judicial role. That's always been there to some extent, but it seemed to me that there was an appetite by people to leave. In terms of a reduction of people coming in, going back to when I was in private practice 20 odd years ago, when you were in private practice, you would accumulate an asset value in your firm, in the goodwill for your firm, and a lot of people, after many years as solicitors, could then trade that against the lack of income during the time it takes to re-qualify as an advocate. But I'm guided that that is no longer really the case. And so you found that people, it became increasingly difficult for them to fund the transition. And that was recognised by faculty who have a subscribed scholarship fund now by existing members who contribute an amount. And that provides a funding resource for people who are keen to come to the bar but couldn't otherwise do it.
I think just to put that in context, because it's something that certainly His Lordship and I are familiar with. In order to qualify as a member of the Faculty of Advocates, one has to do a period, usually between 9 months and a year, of what's termed deviling, where you work with a junior member of faculty, but you don't receive any income from that work. You may be able to supplement your income. I did it by doing some teaching, but you don't get an income from the work that you're doing as a devil. Is that right?
That is right.
So, can we go back to cinema trials? Just a couple of points I'd like to ask you about the logistics and the processes that accompanied cinema trials. Were there any concerns expressed either by you personally or amongst your colleagues about the way in which a jury member in a remote situation watching proceedings on a screen could ultimately take a view on the credibility, the reliability of a particular witness, whether it's by looking at that witness closely or by looking at the accused? Were there any concerns about that?
I do hold the view that when a witness is physically present in front of me, I am better able to read the witness. Juries are now cautioned against placing too much emphasis on how the witness appears because of nerves or whatever. Yeah. And I think that's diluted somewhat when someone becomes remote and is beamed in. But I would say that because it affects both sides equally, in that it would affect the accused giving evidence, it would affect Crown witnesses or defence witnesses, I don't think I have any reason to think that injustice flowed from that. But I was conscious of it.
The other area that I'm perhaps slightly interested in is from your perspective as a practitioner. You would want, very likely, during a trial to consult with your client, as well as obviously having consulted with your client beforehand. But you would want to consult with your client during the trial, discuss developments in the evidence, matters that you wanted to take instructions from the client on. In the circumstances that you were in, with general rules regarding social distancing, was that a problem to be in a confined space with a client, and indeed with solicitors and junior counsel?
It wasn't really possible to maintain the required distancing in those circumstances. What you would find in court is when we moved to the juryless model, the sound system was so good that I couldn't have had a whispered conversation with a colleague here without the jury remotely hearing that. Yeah. So we had to find ways of, I would go off to the corner with whoever it was I was due to speak to, and we would have a whispered conversation to try and make that work. Yeah. In terms of consulting with the accused, occasionally during a trial I might be beckoned to the dock to speak to someone if there's an instant problem. And I suppose that might have happened during the pandemic. That's a rare thing, but the facilities to speak to accused on bail, although there was the provision of the perspex scheme, which I'm sure we're all familiar with from that era, there wasn't much else done that would allow us all to be in the same room and remain safely distanced.
Yeah, thank you. I think also one of the other difficulties may have been, particularly during the early days of the pandemic, were there situations during trials where essential individuals in the trial had to self-isolate?
That was relatively common.
Yeah. And what happened to a trial in that situation?
Well, it would depend on who the personality was, but I had experience of prosecutors, for example, who then had to self-isolate, and do you know, I can't remember if it was 5 days, whatever the period was. By and large, that tended to bring a trial to an end.
Right.
And we would have to restart.
Okay. I suppose the other question on that, if a juror had to self-isolate, could the trial continue on without that juror?
From memory, we wouldn't span the period of self-isolation. The system has the ability to excuse jurors during a trial and to come down from 15 eventually to as low as 12. Yeah. And so that is what we would do then. We wouldn't sit for 5 days waiting for a juror to come back, if I'm right about it being 5 days.
Yeah. Can I just ask you, Mr. Lenehan, you're a highly experienced criminal practitioner, and you were intimately involved in the establishment of the cinema juries. Looking back on this with the benefit of your experience and your reflection, how do you feel about cinema juries? And we're looking at this, I suppose, in the event that there is another situation that requires the immediate closure of courts and an alternative way of dispensing criminal justice, whether or not what happened with cinema juries would be a model that would be followed or could be followed with perhaps less delay than occurred in 2020.
Even with the benefit now of a number of years afterwards, I can't improve upon that model. Mm-hmm. And I would heartily endorse having that as part of a future contingency.
Thank you. One slight aside, and you do tell us at paragraph 50, your statement, that you weren't aware of any difficulty in sourcing jury members, and I think you go on to make the comment that you had the impression that during, particularly the strict lockdown period, jury members were relieved to be given the opportunity, even if it was to come to court, to get out of their own homes for some time.
That would have reached my ears through the staff at what we called the remote jury centres, just speaking to jurors.
Yeah. Right. Obviously, the delay from March 2020 to November 2020, in which no trials took place, brought an end to the trials that were ongoing at March, but also then backed up trials that would otherwise have started in the succeeding months. So we can see, and we've heard, about the backlog of cases. Looking at it from the point of view of clients who were on remand, that would have entailed, probably in the large part, unless they were bailed, I suppose, that would have entailed them being in custody for a lot longer than they would otherwise have anticipated.
Correct.
Were you aware of, or were you critical in any way of that being a consequence of what was happening?
No, I don't think that that could have been handled in a different way. I think that there are people who objectively are suitable for remand at that stage by virtue of either previous offending, previous breaches of court orders, or the nature of the allegation itself. And I suppose it would have been possible to find a way of incarcerating them in their own homes, but it seemed to me that this was not an outrageous way to proceed.
Okay, thank you. We have heard from representatives of the Scottish Courts Service that the backlog is now coming towards an end, and I think that reflects your view, which you express at paragraph 35 of your statement.
Yes, I certainly understood. I'm kept abreast of the output from Scottish Courts and Tribunal Service through some working groups, and my appreciation was that great progress had been made, and I think there is a proposed point where we catch up with where we were relatively soon. And I think that's sooner than we feared it would be if we'd had this conversation in 2022 or 2023.
Thank you. The inquiry has gathered quite a considerable amount of information from prisoners, and that is, I think, now available on the inquiry website. The information from prisoners, and I don't wish to summarize it excessively, but it focuses to a large extent on overcrowding and isolation within prisons during the period of the pandemic, and the cessation of visiting, and the effect on mental health, the adverse effect on mental health of prisoners. Did you come across any clients who, during that period or in your dealings when the courts re-emerged from the pandemic, any instances where that was the case?
My memory is that the most commonly cited cause of unhappiness was the removal of family visits.
Yes.
And I think that, now I don't have the perfect line of sight for this, I'm sure others will speak to you that know better, but I think that there were some efforts to make electronic means of communication more widely available in the prison, but more than anything else, I think that was the biggest issue.
And I think also an area which you make a comment on is at paragraph 39, paragraph 38, and it's in relation to the impact on witnesses and in particular on complainers. And you recognise that delays will have extended a stressful period for them. That's your perspective on it, and we have heard from groups that represent complainers in particular and victims and that is something that the inquiry is very much now aware of, that this was an increased and stressful period for people waiting for trials to take place.
I'm sure.
You accept that?
I'm sure of it, yes.
You also mentioned a little about vulnerable witnesses and also police and professionals and experts giving evidence, and that this can now be done remotely. And I think that was a system that was in train before the pandemic, but has it become now the norm almost?
Yes, certainly in the High Court, and I think it is now being rolled out to become the norm in the Sheriff Court as well.
Right.
And it's valuable, although I made comments earlier on to talk about the dilution of impact of somebody being remote, there are so many other benefits to pre-recording the evidence of some witnesses that it far outweighs any fractional reduction in their impact on the jury, in my view.
And from that stressful point of view, I think we understand, but also, and I don't wish to give evidence from many years ago when I did prosecute, one can remember the time that was wasted in police officers and doctors, experts, scientists, having to be in a courtroom for a period of time before they were able to give their evidence. And that is now a situation where that can be done remotely and at a particular time that is of convenient to the witness.
And leaving them in a productive workplace whilst they're waiting. Yeah.
Yes. Thank you. Now, you do talk about communication with other agencies during the pandemic and also providing information to members of the profession. And I think this reflects what you've already said to us, that once the lockdown occurred and the cessation of court business happened, there was a genuine and across-the-board cooperation between various agencies to ensure that the courts could resume in some way. And you were part of that.
Yes.
Yes. And I think we've heard that from members of the Scottish courts who have given evidence to it. There would obviously be an input into this process from politicians. Again, was that a positive experience at this time?
Yes, I formed a positive view. We had dealings with the then Cabinet Secretary, Humza Yousaf.
Yes.
And I formed a positive view of him and his department's input into this process. It seemed to me that they proceeded with pace, with decisions, at a time when pace was needed.
Yes. You were also, as an organisation, a conduit between information that was coming from, presumably from government or from the Scottish courts, to your membership, and you were in a situation where you, as an organisation, would be giving guidance to your members. I think you've again indicated that that was a positive exercise. We have heard in a number of perhaps other situations where information that was coming from government was coming too frequently and often in a way that was confusing. That wasn't your experience.
No. Our two sources were either from direct discussions or via the Dean of Faculty. So the Rory Dunlop Casey became Dean in 2020, and I thought was a very effective communicator.
Right, can I move on to towards the end, Mr. Lenehan, to the impacts on the membership of the profession, and in particular the criminal bar that you represented during the pandemic. There was obviously, and I think all of us who have practiced understand that, there was an immediate financial impact on members of the bar who were practicing in the criminal courts. Is that right?
That is right.
Yep. And associated with that financial impact would likely be an impact on mental well-being.
I'm certain of that.
Yes. Also, the bar is famed for being a collegiate organization. There is social interaction between members of faculty. And when the courts closed, that presumably was something else that was denied to members in the sense of personally interacting with somebody, or be it, well, one could do it over the telephone or FaceTiming or whatever.
Sometimes you don't know what you've got till it's gone.
Yes.
And so it did become obvious when I was no longer rubbing alongside colleagues how much, in fact, I valued that in the years leading up to it. Mm-hmm. But you notice it when it's not there.
Yeah. And it's not just information from a colleague who can tell you about, well, in this particular situation, this is perhaps what I would do, or you can perhaps pass on. It's simply companionship and friendship.
I found that, yes.
Yes. I think the faculty has recognised that. And as you tell us, there has now been the appointment of a full-time mental health and welfare officer in the faculty.
It became acutely obvious to faculty and the criminal bar, perhaps particularly, the negative impact of the stresses surrounding the pandemic. It loops back to the discussion at the start, the fact that we're all sole traders. It means that there isn't a safety net in the way that other partners within the criminal justice system who are employed. That does not exist for sole traders. And so it meant that people, even though advocates by and large earn a substantial amount of money, you have a substantial or commensurate amount of outgoings. And so when the money side of it stops, the outgoings didn't. So school fees didn't, mortgages didn't, all of these various things. And it put a lot of pressure on people because we also didn't know how long this was going to be.
No. And I think, distressingly and tragically, there were 3 suicides amongst members of the Faculty of Advocates during that period.
That is the case, yes.
And you you very openly tell us that in relation to the financial assistance that was available, you in fact took advantage of that.
I did.
I've asked you about the depletion of numbers in the criminal bar, and I think you've indicated that. Can I just take you to your conclusion? Because I think very powerfully in your conclusions, you say the effect of the pandemic on you and your colleagues at the criminal bar, and I can just take you to paragraph 63. I'm sorry, I got the wrong paragraph. Yes, sorry, it's paragraph 68. I apologise. You tell us two things there, if I can just pick them out, was you feel that there was a decline in the professional respect for the criminal bar over the last 10 years. And that obviously takes in a period before the pandemic, includes the pandemic and post-pandemic. Do you feel that the pandemic and what happened during the pandemic exacerbated that decline?
I think that it brought into focus in my mind the existence of the decline. I'm not sure the pandemic itself, well, during the pandemic there were examples of the fact of that decline as I saw it amongst the senior judiciary. I wasn't left with the sense that the value that I place on the role that my colleagues do was shared by some members, not the majority, the way I had the sense a decade ago, 2 decades ago, it was there. So I think the pandemic served to provide examples to let me see what had happened.
It put it in focus.
Correct.
Your ultimate conclusion, Mr. Lenehan, is that the criminal bar, as you put it, was devastated by the closure of the courts, and you refer to your 20 years in practice, and I think you also had experience before you came to the bar. Nothing came close to the negative impact of the pandemic on that part of the profession. And
correct.
I suppose one hopes it never will again.
Yes.
Mr. Lenehan, that's all I have to ask you, unless there's anything you would particularly want to add for His Lordship's consideration, or anything that His Lordship wishes to ask you.
Not from me, thank you, my Lord.
No, thank you, Mr. Gillen. Thank you, Mr. Lenehan. Plainly, I had some insight into much of the evidence you gave, as you would imagine. I'd just like to say that this particular member of the senior bar has no declining of his regard for the criminal bar. I hold it in high regard and always have and always will.
I was sure of it. Thank you, my Lord.
Yeah, that's all. 11:15. Now, good morning, Miss Trainer.
Good morning, my lord.
Now, you have a witness for me?
I do, my lord. This is Stuart Valentine from Relationships Scotland.
Good morning, Mr. Valentine.
Good morning.
Right, on you go, Miss Trainer.
Thank you. Mr. Valentine, you are Chief Executive Officer of Relationships Scotland, is that right?
That's correct, yes.
And you have kindly provided a statement to the inquiry which will form part of your evidence today, and for the benefit of our records, the reference for that statement is SCI WT 012750 and then a number 1. Now, as you will be aware, your evidence today is intended to supplement that statement, so please be reassured if there's anything we don't cover today, your full statement remains before the inquiry. You tell us, first of all, within the statement that you have been in your current position since 2007.
That's correct, yes.
And so you're well aware of the operations of Relationships Scotland throughout the pandemic.
I am, yes.
I wonder if then you can start by telling us a bit about Relationships Scotland and what they do.
Yeah, certainly. So Relationships Scotland, we're a nationwide network, and we help people who have relationship problems and who are going through separation and divorce. We provide services to people wherever they live in the country, right across the whole country, from Shetland, Orkney, all the way down to Dumfries and Galloway, and everywhere in between. We see around 20,000 or so people are helped by our services. We primarily provide relationship counselling, family mediation, and child contact centres. And we have 21 services operate at the local level across the country, all of whom are independent charities in their own right, but all of whom are members of Relationships Scotland and form part of the Relationships Scotland network.
So your Relationships Scotland, as I see it, has almost a national office.
It does, yes. So I'm the Chief Executive of the National Office, and we work very closely with our 21 services across the country and support them to provide the services that they provide.
Do each of them have their own board?
They do, yes. All 21 of our, what we call our member services, all have their own boards of management, boards of trustees, and they are independent charities in their own right. But we work very closely as a network, and that's a key part of how we work is working and supporting one another. And the National Office has a particular role in providing training, fundraising support, professional practice support, CPD, etc. for our whole network.
You mentioned the services that the member services offer. Am I right in thinking there really are three main services? You mentioned counselling, mediation and child contact, and member services can offer a combination of those services or just one of them?
That's right. Some of our services would mainly provide relationship counselling, some would provide mainly family mediation and child contact centres, and then 7 of our services provide all of those services in their area. So if you took Orkney, for example, they provide relationship counselling, family mediation and child contact centres.
You mentioned the service being aimed towards persons who are experiencing a family breakdown, separation, perhaps involved in divorce proceedings. Yeah. How do people then, in those scenarios, access the services?
There's a range of different routes for people to come to us. So it can be people can self-refer, they can come to us directly ourselves. Often they may be referred by either social work or perhaps their GP, in particular if it's for counselling or for mediation. We also have a significant number of centre services, whether that be supervised contact or supported child contact. So there's really a range of different routes that people can come to us from.
We've obviously mentioned now multiple times the 3 key services that you offer. Are you able to briefly explain what each of those services provides?
Certainly, yes. So relationship counselling is what would traditionally been previously known as marriage guidance counselling. This is counselling often for couples who are having relationship problems but are still together and maybe looking to hopefully stay together as a family. We provide family mediation, and that would be in the circumstance where they often have children, often young children, and they're struggling to agree arrangements following separation and or divorce. And family mediation would have essentially a qualified family mediator who would help that separating couple agree the arrangements for looking after their children after they've split, where the children live, how often they see their parent, the resident parent or their non-resident parent. So that's the heart of what mediation is about. And then our child contact centres provides a safe place for non-resident parents to see their children after separation and divorce, and that can often be when there's been quite a difficult breakup, and maybe they just cannot arrange that themselves anymore. And as I mentioned before, that's often, if it's the case, that they've had to go to court. If one of the parents has had to go to court to find a way to see and have contact with their child, that may be a referral from the court that would ask for contact to happen in our child contact centres. And the crucial role they play is that the child can see their non-resident parent without the two parents having to meet each other, because often that can be a time of significant conflict where people have separated. In our child contact centres, make sure that the child can see their non-resident parent in a safe and manageable way.
Those services, of course, sound and no doubt are quite intensive in terms of the amount of input from staff and sometimes volunteers. How generally are the services funded?
Approximately half of the amount of money for running our whole network comes directly from the Scottish Government. So we receive funding through the Cora Foundation, and we also receive funding directly from the Scottish Government to support our child contact centres. So around about £5 million a year is the total income from our network each year, and 2.3 million of that comes directly from the Scottish Government.
At paragraph 11 of your statement, you give us a breakdown or some numbers in terms of the staffing of the services and the organisation, and you tell us first, I think, that pre-pandemic there were around about 900 staff across the network.
That's correct.
And do we then later see that staff really range from persons who are in paid roles, but also there are volunteers who are both trustees sometimes of the individual member services and then provide the services themselves?
That's right. So we would have many either full or part-time paid staff. We'd also have a lot of practitioners who may work essentially on a kind of sessional basis for us. And then, as you say, we have a number of, quite a significant number of volunteers, many of whom are also the trustees on each of the 21 service boards.
I think we see from your statement, you narrate around 400 of the staffing number being volunteers.
Yes, that's right.
You also tell us about some of the locations in which those persons are working, and of course some of them being office-based at least, but then you discuss there being a use of more public spaces, more community-based spaces for some of the child contact centres. Yeah. Is that right? That's
right. We use over 300 different actual venues to deliver our services. We try to make sure we can deliver those services as close as possible to where people live. And as I say, we've 21 services across the country, but they deliver the actual face-to-face provision from over 300 different venues. And that can be church halls, GP surgeries, local community centres, a whole wide variety of different places that's delivered. And certainly in our island communities, they may also have a number of venues that are just used from time to time. Others would be used on a much more regular basis.
You then logically go on in your statement to discuss the effect of the pandemic on the running of all of those services. I wondered how, in the immediate impact of the restrictions being announced, were the services affected?
Certainly in the very early days, they just came to a stop immediately. We had only very little online provision for our services prior to the pandemic, but we were very quickly able to establish. Initially, counselling was the first service that was the most straightforward to move on to online, and we very quickly had essentially training input for our counsellors. I remember one day having a Zoom training call. I think it was within 10 days or so of the pandemic. We had 80 of our counsellors on that call, and essentially we were giving them the tools and knowledge necessary for them to be able to go on to provide counselling online. We were very pleased that within a very short space of time, maybe 4 to 6 weeks or so, about 80% of the clients who had been receiving counselling face-to-face were then receiving counselling online. And not long after that, we were back to numbers very similar to before the pandemic. So certainly for our relationship counselling service, it was very quick and relatively straightforward to deliver that service. There were still some people who hoped that the pandemic would be over quickly and anticipated that, and they were wanting to wait and see and go back to face as it went on, and it became clearer that that wasn't going to happen quickly, and more people agreed to come on and have that service online.
Later on in your statement, I think you discuss perhaps in more detail what happened in relation to the operation of contact centres and mediation, and we will get to that.
Sure.
But first of all, I wondered, in terms of the impact on the staffing of the organisation, you mentioned there a little bit about online training. I think at paragraph 19 you tell us a bit more about online training and how that, of course, was really forced upon the organisation because of the restrictions at the time. Do you think that at all impacted the quality of the training you're able to provide?
Not really. I think it did work well, I have to say, and certainly the circumstances that we were in, we were very quickly able to get our practitioners, our staff, up to speed, to have them with the infrastructure they needed in their houses to do this training. And it went very well, I've got to say. It did work well, and we were able to provide that training directly to people online. Slightly different, of course, different arrangements, more needs for more regular breaks because people would get more tired more quickly when the training was being delivered online. But there was a relatively smooth transition given the circumstances that we were in.
Then in your statement at paragraph 22, you go on to tell us about the financial impacts, both immediate and perhaps longer term on the organisation. I wondered if you could summarise financially how the restrictions impacted you.
That initially was clearly a very significant concern in the early days. I would have to say that both the Scottish Government and the Cora Foundation were excellent in terms of reassuring us that the key thing in those early days of the pandemic was about maintaining the structure and viability of the network. And they were saying, if it was the case, for example, that some staff might be getting paid and were unable to do work, that, in a sense, that was fine. The key thing was to keep our network strong and be ready for when we started to move out of the pandemic. And those funding arrangements were very reassuring and very helpful. There was also a number of grants made available through the Cora Foundation in particular during the pandemic that our services were able to access. I would say that I don't think any of our 21 services nor the National Office suffered particularly badly during the pandemic, and indeed for some it was a chance to bring in additional funding to be able to provide services to people either at little or no cost, which was very helpful indeed. There was also the combination of business tax relief that meant a lot of our services were able to access. Again, that was helpful. The furlough scheme was used, not massively within our network, but in some cases it was appropriate and it was used, and again that was very helpful.
I think you at paragraph 24, interestingly, anecdotally tell us that there at least was one premises in which a landlord didn't require rent for a period in order to allow the organisation some grace in terms of payments and outgoings. That's
right. That was in your place in Edinburgh. The National Office was given a rent-free period by our landlord, and that was very good of them and very welcome.
In terms of the staffing levels, you tell us, I think at paragraph 29, that of course, as would naturally happen, some staff did leave the organisation during the pandemic. But you say, I think I would say that it was happening more than before the pandemic, and we are only now reconciling with that. And I wondered if you perhaps might tell us why you think that is and what impact that had on the organisation.
I think it was a time of reflection for many. So there were some people who might have been close to retirement age who took that opportunity to maybe go a little bit earlier into retirement than they thought before. It appeared that the pandemic was a time for many people to reflect more widely on their life and what they were looking for, and maybe they used that as a time to decide that there would be a time to change. For some people it was burnout, the combination of the challenges they were facing both at home and at work with all of the change was just too much. That said, the vast majority of staff across our network remained in place through there, but there clearly was a number who decided to make a change at that point.
You also say, which was of interest while I was reading your statement, that a year or two after the pandemic, you saw some sickness, absence in particular, within the member services increasing. Again, can you tell us why you think that is?
I think as far as I can tell, that was, again, I guess, just linked to the additional pressures people had, whilst our network was there to provide support for children and families across the country. They themselves were parents, themselves family members, themselves affected by everything that was going on, and I think it was a combination of them both. The challenges they had, both at home and at work, may have led them to think that was the right time to go at that stage. So I think it's just a combination of everything, and in general a period of time when people reflected more deeply on their lives because they hadn't gone through something like that before.
You go on within paragraphs 35 to 38 of your statement to give us some examples of instances where staff's lives were perhaps made a little bit more challenging by things that the necessary changes to the services. And I wanted to pick up on some of those, and in particular in paragraph 35, you discuss the mediation service and say that staff found it difficult at times to deliver that service online. I wonder if you can tell us, in relation to the impact on staff, how they found that and how that affected them.
I think it was just me. We were very fortunate we got such dedicated staff and volunteers in our network, and I think the additional challenges they had in providing the support that they wanted to would have had an impact on them. I think, in the statement we've given highlights some of the challenges, say for example around providing mediation. That can be challenging outside of a pandemic, much more challenging when it's happening in a pandemic, and I think that was just, I guess, another part that our staff did find difficult and challenging going through that time, because they wanted to provide the best service they could, and the pandemic made that all the more difficult.
At paragraph 38, again, you give an example or examples of the contact centre service in particular, and tell us that staff at that time had to manage quite difficult calls from service users, typically parents. Are you able to tell us more about that?
Yeah, I think for many people, if you think of the circumstance of a dad, for example, who's maybe not seen his children for a year or more, and they would have had the hope of a court process that they believed would end up resulting in them being able to see their child, and then when the courts essentially closed, that closed a door to them in terms of the hope they had, at least before they were in a they were in a process where they believed that this was leading to them being able to see their child again. When the courts closed, they were then faced with thinking, will this ever happen? And there was certainly a significant increase in the number of people who were either suggesting they might self-harm or they might commit suicide as a result of that. And that, of course, has the added impact onto the staff members who are having to provide that additional support. And they themselves, the staff members, needed additional support because of the type of issues that they were having to face.
That then leads on, I think, naturally to discussing particularly contact centres and the effect the pandemic had on those services. Firstly, I think you say in paragraph 39 that there are around 42 child contact services or centres in total that the service runs.
That's right, there's 42 child contact centres across the country that are run by our network.
And you go on to tell us in paragraph 39 that I think the majority of those referrals, the vast majority, 85%, come from courts and court orders. They
would come from either solicitors or courts, yes, through essentially through the legal profession, yeah.
His Lordship, I think, will be familiar with that process, but I wonder if you could perhaps outline in what circumstances, or in the circumstances in which a court might make a referral to your service.
Essentially, the most common scenario would be a dad who is not able to see their child because they can't agree that with the partner that they're no longer living with, and they may have exhausted a range of other options. They may have tried potentially tried mediation. There might be other things they have tried, but in those circumstances where the two separated partners cannot agree and will not agree for contact to take place, often the only option remaining for someone in that situation would be to seek a court order to get contact to see their child.
And when a court order is made, are we to understand, is the court process still ongoing throughout the time that the referral is made to your service, or is it come to an end, or can it be both?
I think it's both. Often, if it's supervised contact, there will be reports sent back by our services to the court to say how that contact is going, and in those cases that would be ongoing, and the final decisions would not yet have been made. It would just be an ongoing process.
You have referred already to the fact that in March 2020, when restrictions were announced, that the centres required to close immediately. What then happened to the service, and were there alternatives offered?
It was very, very challenging for our child contact centres. So there were some other options put in place. There was what was called a postbox service, which was essentially having the non-resident parent being able to write backwards and forwards to their children. That had to be done safely, so our staff essentially would be a go-between there, where we would make sure that anything that was being sent to the child was appropriate and was safe. That service was very good that we could offer it. It worked well for some. For others, it was slightly more difficult. It was quite a difficult process, I guess, and for some people it was a lot of effort for not necessarily that much gain. They still weren't able to see and spend time with their child, but we wanted to provide what we could, so we're being as innovative as we could as a network to try to enable some level of contact to be made within those circumstances. Again, it was very difficult to organise, say, like online video contact. It did happen in some cases, but not on a large scale. That was particularly challenging to try to operate.
Picking up on the postbox contact that you mentioned, was there an intention that was a reciprocal arrangement, or was it simply one way, a parent sends something to a child, or was the intention the child also sent something back? The intention
would be both directions. Of course, to do that you need the agreement of both separated parents. Sometimes a resident parent may be less keen for contact to be taking place, and so there are even more hurdles to jump through than normal in those circumstances. So, as I say, for those families that worked for, that was very good. It wasn't massive numbers, and certainly nothing like the numbers that would normally be happening outside of the pandemic.
I think you say in paragraph 41 of your statement that there was at least limited uptake of that initially.
Yeah.
As people started to realise that perhaps this was not an issue that was going to be resolved as quickly as one might have hoped, did that uptake pick up?
I would say not significantly. I think it was always a relatively small number of people who accessed that service, but I think for our staff and volunteers it was very useful that we were able to offer something, and there was something that could be offered to people in that circumstance. But it wasn't massively taken up as a service, because it was quite challenging, and it didn't result in non-resident parents getting to actually see their children. It was just through letters, so it was important for some. It served its purpose, but there was never a massive take-up of it.
And in terms of the role of the contact centre staff in that, would they be involved in reading or looking at the correspondence to make sure it was appropriate to be sent on? That's right. The key thing with all cases that involve contact, all of our services, is the safety of all those involved, and that was the safety mechanism, was that any communications were done through our services, and so letters or anything that was being sent through was checked to see that was appropriate and was okay before it would be sent on, and that was the key part to ensure that everybody was kept safe. You then mentioned, I think, effectively online contact, so happening via video call, is that right? That's right, yeah. And I think you say again at paragraph 40 there was minimal uptake of that, at least at first. Yes. How proportionally do you know, I mean, compared to, for say, the amount of people who took up the digital postbox service, did more or less take up the online contact? I'd have to double check to know exactly. I would say
probably less than the postbox. It was particularly challenging to do that, especially when you're in most contact situations. You are dealing with people who have had a very significant breakdown in their relationship. There will not be goodwill there for one another, and that can be challenging at the best of times. Much more challenging if you're actually trying to, say, set up online calls from a partner you don't want to see to take place with your child in your home. That's very, very challenging, and that in part would be why there was such small uptake of that service.
And again, the role of the staff in that, would they be on the call monitoring the interactions that they were
Absolutely.
appropriate?
Yes, they would always be part of anything of a contact. They would always have staff around for that. And that would be the case with online contact as well. The staff would be involved, and that call would be in a position to end that call if needed, if anything was to happen that was deemed to be not appropriate or not safe.
And what about the resident parent in that scenario? Would they be part of the call, or were they expected to not participate?
They would not normally be part of the contact time between a non-resident parent and the child, but clearly if they had the care of the child and that was taking place in their home, they would have to be involved in the process to help facilitate it.
Perhaps then the resident parent might have even more of a role in contact in an online scenario than would be the case in a contact centre.
Yes, that's right. I mean, the main role at a contact centre is simply bringing the child to and from the centre. Where it was online, there'd be just all of the whole kind of setting up of online calls, whether that's on Zoom or Teams or something of that nature. So yes, the non-resident parent would have a much bigger role again, and that just adds to the number of hurdles you have to get over for something to actually take place.
I think you tell us at paragraph 14, you've already alluded to the fact that in these scenarios where these alternatives, new alternatives, were being offered, that required the agreement of both parties.
Yes, that's right, yeah.
And we're, at least in 85% of these cases, these are arrangements by court order, so it's not necessarily lends itself to parties agreeing matters.
Yes, yeah. In almost all of the contact cases, we were dealing with goodwill and cooperation between the separated parents is in short supply.
Are you aware of some of, I suppose, the reasons that people gave for refusing to engage in either the online contact or the postbox contact?
I mean, I guess largely, as I mentioned before, I think the ratio of effort to outcome was a big part of it. As I say, even in normal circumstances outside of the pandemic, to get contact to happen when there has been clearly a difficult separation is very challenging. And in the pandemic, essentially, there was multiple other hurdles to get over, and that was the biggest part of it. I think it was just much more difficult to arrange, and many more reasons for the contact not to take place if the resident parent was not keen for it to happen. There was many more reasons could be given for it not to progress.
You mention in paragraph 39, just generally, that time of the contact centres closing being a time of huge anxiety for parents. And you say that the problem was, first of all, of course, the centres had closed, but second of all, was compounded by the fact that court hearings weren't happening. And then third of all was compounded by the fact that the schools were closed. I wonder if you can tell us about the interaction between all of those things and why that caused such an anxious time for parents.
I think for many people whose contact hadn't even yet started, as I mentioned earlier, that was the whole process ground to a halt. So for those people who were not already, in the process of having contact, as I mentioned earlier, their hope at that stage would go because they just didn't see a route forward, and it was not clear at various stages how long this would happen, how long this would go on for. So that was clearly very difficult. All of our families were dealing with the impact, especially those with young children, of schools being closed and having to run essentially a school from within their home. That was very difficult. We know in the more general sense of our work, for many families, being in a house together 24/7, and it being a restaurant, it being a school, it being a place of work, and trying to balance all of that was enormously stressful. And whilst lockdown was good for some people enjoyed it and thought it was a good experience, there was many others who found it incredibly difficult, and the kind of family conflict was significantly increased during that time for those families that found it difficult.
I think in particular, one of the things that you pick up on in paragraph 39 is that for a parent who is a non-resident parent who might only be seeing their child at a contact centre in very limited circumstances, getting information about the child is something which is crucially important to them.
Yeah.
And you say, I think, that schools shutting had the impact that additional information about how their child was getting on and how their welfare was progressing wasn't able to be passed on.
I think that's right. I mean, it became more key, I guess, the role of the resident parent in that circumstance to pass on and share information. And again, if we're in the context of two people whose relationship is broken down extremely badly and are not do not have goodwill for one another, then that's going to be a much more difficult process, and much more difficult for the non-resident parent to get information about what's happening with their child.
You then, I think, after the initial lockdown period, you go on to tell us in your statement that from around, at paragraph 43, from around August of 2020, the organisation felt able at that time, because of the guidance that had been issued, to offer outdoor contact in some centres and in some circumstances. Yeah. Can you tell me, first of all, how that was rolled out effectively?
Yeah, I mean, essentially it was just the process of the gradual easing of restrictions. Then it was evident that we were able to provide the beginnings of a service moving backwards. It would have started slowly. I think there'd been a nervousness all round at that stage after everything that people had gone through. But those were the first steps, I guess, to the child contact centre services moving back to being able to have the non-resident parent and child to be able to physically see each other and spend time with one another. I think that was greatly welcomed, but again, very small numbers initially, and nothing like what we were dealing with before the pandemic. So it was very much just the beginnings of the stage of going back to something like it was before, but it was just the very early stages of it and not very high numbers.
The centres that were identified as an appropriate place for that, I presume that they were the centres which had a large outdoor part of a place that you could use for the contact to take place. Yeah, I
mean, some of our centres would have had that themselves. I think other centres may have used just outdoor, common outdoor space that could be accessed there. So as I say, some of our services do have that space within their own premises. Others, I think, would just have used common outdoor space that they deemed to be safe to use.
You then go on to talk at paragraph 44 about there being a lot of variation in particularly local authority premises that the member service used, and that some local authorities interpreted guidance in different ways across different areas. Can you tell us about some of those problems that were experienced?
I think it was just, I guess, an awareness that there was a different speed of reopening the spaces that the local authorities would allow the third sector organisations like ourselves to use. There may have been perfectly understandable reasons for that, but when we were working across so many different local authority areas, we work across all 32, we were able to see that there were differences, I guess, in the speed of the opening up of those space. I wouldn't use that as a criticism, I'd have to say. I think every local authority would have their own challenges and their own reasons for doing things, but I guess when we were very keen to resume the support services that we offer, there was, I guess, a level of frustration from our staff that we thought the rules would then allow us to start using premises, and it seemed to go slightly slower than we would have hoped for.
I think you narrate a sense that local authorities, perhaps speaking very much in the generality, but were more risk averse than you as a third sector wanted to be at that time.
I think we followed the guidance as it came out, and we have to say we found the guidance from the Scottish Government incredibly helpful. They provided specific guidance to our child contact centres, and they consulted with us before putting that in place. So it was an excellent arrangement there. You know, there may have been other reasons why local authorities were slower to open their premises than we were aware of. We had thought and had hoped it would have been better had it gone a degree faster, but I'd be hesitant to be critical of them for that, because there may have been other reasons for why that was the case.
Yes, I mean, I think without criticism in your statement, you just say, as a matter of fact, as lockdown eased, it just was simply often the local authority premises that were last to reopen.
Yes, yeah, that would be accurate, yeah.
You then go on at paragraph 46 of your statement to talk about the different stages of restrictions for supported contact. We obviously know that there were different restrictions at different times and different guidance issued at different times to do with things like social distancing and face masks and the like. Was that something which translated into the contact centre setting?
It was. Every time there was, I guess, a new update from the government in terms of the ways that things could be done safely and appropriately, that would be fed out to all of our services, and it was just a staged easing of restrictions, essentially, and we just followed them to the letter. It was at times it was very clear and very helpful guidance we were getting about how we should operate, and we ran our services in that way. At times it was challenging for clients. They may have had their own views about whether these restrictions were right or not, so there was a frustration there, and I guess an additional burden on our staff to have to explain the reasons for why we were doing things in a certain way. But in terms of the guidance that we got, both national level, watching the briefings every night from the First Minister, plus the detailed guidance we got in relation to child contact centres, that was incredibly helpful for us.
At paragraph 45, you mention when parents visited the contact centres that were open, some of them complained that we, presumably the centre staff, weren't in full PPE and didn't seem aware that we all had to wear face masks. And I wondered if you could explain whether face masks were used in contact centres and whether that posed any issues.
I mean, yes, they would have been. Wherever it was that was the guidance, and that was what would have been followed. I think that's when you got into the territory of at times people had different views on whether or not the guidance was right. We followed the guidance, and that's what we would have advised the children and families who came to us for support. But of course, everyone would have their view. Some would think the restrictions weren't strict enough. Others would think they were ridiculous and shouldn't be there at all. And that's what we had to face in terms of working in such a close way with the families who came to our child contact centres.
You also later mention, I think in the same paragraph, that in some instances parents wanted to know if the staff were vaccinated, and so the working relationship became perhaps a little bit more challenging than it was before.
I mean, yes, that would be, I guess the questions are more personal you would normally get in that circumstance. We would reassure the people who are coming to us for support that our staff were vaccinated. I believe that was the case. And I guess it was just another example of more questions people would have to ask about what's happening to their children and their family when they come in to use the services that we were providing, and that was just, I guess, part of what we had to reassure people about.
In terms of the long-term impact on contact centres, I wondered, were there any elements of the service which changed during the pandemic that have persisted now and are going to be kept? Or is it gone completely reverted back to what it previously was?
With child contact centres, it's pretty much reverted back to what it was pre-pandemic. That's not been the case for relationship counselling. It's not been the case for some of the training that we provide, some of our CPD events that we provide. The benefits for the online service in terms of, say, counselling and training, as I mentioned, were very good. In some ways it worked better, and for those elements where there was an advantage for them to be online, we've kept that. Very little of what we did during the pandemic for child contact centres would have been kept. It's all about face-to-face contact between parents and their children, and that works best in person, and that's why it's gone back to being essentially the way it was before the pandemic.
Turning then, in your statement you go on to discuss the impact on the mediation service. First of all, do you know how many mediation services exist across the network?
Yeah, so we have, as I mentioned, we've got 21 services across the country. 13 of those provide family mediation, but they do that for the whole country. So those 13 services cover the whole of Scotland offering family mediation.
So there's nobody who isn't covered by a service, effectively?
Yes, if someone lived anywhere in Scotland, they could access a family mediation service through the Relationship Scotland network.
In paragraph 48 of your statement, at the end we see the statistics for the referrals to that service, and we see quite a significant change in terms of there being far less, only 20% from solicitors and 9% from courts in relation to mediation, and there being far more in terms of self-referrals, that being 56% of the referrals for that. That's right?
Yes, that's correct, yes.
And that difference, I suppose, might indicate that in a circumstance where families might want mediation, it might require them to be more cooperative than it being directed by a court.
Yeah, that's correct, yes. Yeah, that's right.
Again, prior to the pandemic, were mediation services typically conducted in a face-to-face environment? Yes,
almost all would be done, and whilst now some would still be done online, that is a service that works best face-to-face, and say, unlike counselling, where a significant proportion remain online for counselling, with mediation we're moving back to the vast majority are be done in person.
Clearly, you've spoken about, again, when restrictions were announced, that service having to come to a standstill, and thereafter in your statement you discuss the setting up of that service online. Are you able to tell us how that worked and how service users found it?
Yeah, it was more challenging. I think, again, when you've got, if you compare just very briefly, a couple coming for counselling who both want to come to counselling together, and compare that to a couple who are separating and not agreeing about the future care of their children, you will often have one or both parties perhaps reluctant to come to mediation initially. So already you're in a situation where getting the cooperation of everyone involved can be challenging. When you add that on to then have all of the online issues, the technology, the when will this happen, space and time, and a key thing that came out was, just to give one example, was that to have the voice of your ex-partner in your house for some people was very challenging. That was not something they welcomed, and that was an additional, I guess, hurdle for people in mediation. On the flip side of that, you had some people who preferred being online for mediation because it meant they weren't in the same physical vicinity as their ex-partner, and for them that was a plus. So I guess it was a range of different experiences, but in general terms, is providing family mediation online is much more challenging than trying to do it in person.
I think you also say in your statement at paragraph 47 that, for example, if one person was more reluctant to engage, then they simply just had more excuses not to take part in it because it was online.
Absolutely, that was the heart of it. It was similar to child contact as well, in a sense. If you did have one person who was not that keen on doing it, there was 10 other reasons to suggest there might be a problem with going ahead with this.
Another thing I think that you raise is that, of course, if people are participating in mediation, typically there is a reason, there is a topic that they need to discuss or something that they need to resolve, and that when the pandemic happened, whatever that issue was perhaps took a back seat, and pandemic issues, so discussing arrangements and restrictions and discussing what was going on in the changing situation at the time, was what the subject of the mediation became. Absolutely, people had just so many more things on their plate. As I say, people working from home, people having to run schooling and education from home, all of that, they for a time became much more pressing matters than continuing to pursue what the issues would normally have been through mediation. You spoke about there being, certainly compared to child contact, some positives to do with online mediation. Again, do you still have that as part of the service, and proportionally do you know how much is online and how much is back to face-to-face?
If I was estimating, I would say it's less than 10% or so would be online. It's not like counselling. Counselling's maybe still nearer 50-50 or so in many of our services. So much less, and as I said, mediation works much better in person. So it'd be a small proportion would be online in terms of mediation now.
You then go on, and we've referred to it already, but the counselling services that the organisation provides, again, do you know how many services you have across Scotland for counselling?
Yeah, 15 of our 21 member services provide relationship counselling, and likewise, as I said before, that covers the whole of Scotland.
And again, talking about where that comes from, am I right in saying that would never be something that was court ordered, because this is couples who want to come to discuss a relationship that might need worked on but hasn't broken down fully yet?
Yeah, I mean, typically referrals for counselling, they would not come from the courts. They would typically come from self-referrals, would be a vast majority. Then also GP surgeries, perhaps other third sector organisations may refer to us, but the vast majority who are coming to counselling would be self-referred.
You tell us at paragraph 49 that you were able to mobilise that service online very quickly. Why do you think that was compared to perhaps the other services?
I think in part we had done some online counselling before, so it wasn't an absolute standing start for us. It's a more straightforward process, and the biggest part of it is the cooperation and willingness to engage from the people themselves. If it is a couple, they're very often living in most circumstances in the same house. They're willing and wanting that service to happen, and the kind of closeness of interaction between people over Zoom or Teams or another platform like that, it does mirror quite closely to what happens in a counselling room. There's some nuances that might be missed, but there's a real ability of skilled counsellors to be able to engage in a very similar way with either individuals or couples who are coming for counselling, to be able to do that online. It's a pretty similar experience, whilst not being exact, and for some people it does work very well. There's no travel involved. Some of the areas we cover are vast, Highland for example, and online counselling works very well.
That presumably is why, at least to a far greater extent than mediation and contact centres, the online service does persist and will persist for some time to come.
Yes, that's right. Yeah, I would imagine there will always be a significant proportion of the counsel we will provide as a network would be online.
Then, moving on from the individual services that you provide, you go on in your statement to tell us about your experience as an organisation on the impact of court closures, particularly on the service users that you were serving at the time.
Yeah.
And you tell us at paragraph 51 that the impact of courts closing during the pandemic was difficult for the families that you support. What were those families communicating to you at that time?
I think it was part of the struggle was just about, in a sense, if people are engaged in a process, if they're wanting to see their children again who they've not seen for a long, long time, if they believe they're on a road for that to happen, then they're travelling with that hope and that destination. With the courts closing, essentially that whole process just stalled without any clarity about when that might start again. And for many people in that circumstance, that was really devastating. There was a significant increase in people saying they felt they may be at risk of self-harming. People were reporting they were considering suicide as a result of it, and that was clearly very, very distressing for them, and also very challenging for our staff and volunteers as we tried to support them.
I think you also mentioned there's an added impact that people felt they had either little or no access to the solicitors that were supporting them through that court process. I take it that was something that was reported to you at the time from service users?
Yes, I think just many of the normal services that they would have been able to access just weren't there, and a big part of what we did with the families who were coming to us was to be there to speak to them. So in many circumstances it wasn't so much about providing a direct service to them as such, it was also just being there for them and for them having someone to speak to explain what was happening to them and for us to support them as best as possible. The courts closing was very, very challenging for those who clearly had hoped to find a route through to see their children, and that was coming to a stop.
At paragraph 53, quite starkly, I think you say many people had given up on obtaining court orders during the pandemic. As a consequence, some are now disconnected as families.
Yeah, we would guess that there will certainly be a significant number of people who simply gave up through that process and may not have restarted again, and that would have been a lasting negative impact of the pandemic on their lives and the lives of their children. We would always hope that when it's safe to do so, non-resident parents continue to be involved in the life of their children, and that's quite devastating if that doesn't happen when it would have been safe for it to have done so.
You go on at paragraph 54 to discuss anecdotally and also I think from research done by agencies which your organisation is aware of and is very alive to, that there was at least a reported to you increase in tension or escalation of domestic abuse within families during that time.
Absolutely, that we were receiving more reports of that from our clients. There was also, I think at the time, significant research done around that issue, and quite rightly extra funding we made available to those services that provide particular support for people affected by domestic abuse. But certainly that is something we did experience, and we would have been referring those cases to specialised domestic abuse services whenever appropriate.
You also note, perhaps definitely more positively at paragraph 55, that due to the courts and contact centres being closed and the lack of access to solicitors, a small number of families decided to be resilient and sort child contact and mediate themselves, which in some circumstances, of course, worked well and was a better outcome.
Yes, yeah, absolutely. I think that was the case. Some families did just think, well, we're not. If no one's going to help us to do this, we may try and do that. And then you may have found a level of cooperation between some separated parents that was greater than usual. There's always potential inherent risks in that. This is often better as a supported service, but certainly some people would have gone ahead with that on their own, and in some circumstances it worked well.
I want to move on to discuss something which you have raised already, which is the communication with public agencies at paragraph 60 of your statement. You've spoken already about how you feel certainly the Scottish Government communicated messaging to you in a positive way.
Yes.
And you say that specifically the Scottish Government contacted you at the start of the pandemic. You spoke frequently with civil servants in the Family Law and Justice Department, particularly around child contact centres, and that resulted in specific guidance being issued to you by the Scottish Government in relation to centres themselves. That's
correct. That worked extremely well. I have to say we were very well supported by the Scottish Government through that process. They knew and were aware of the particular challenges that our child contact centres were facing, and as I said, they provided specific guidance for our child contact centres, which was very welcome, and importantly they discussed that and consulted us on that in advance of it, which, in one sense we couldn't have asked for better collaboration with our colleagues in the Scottish Government around that, and our network was hugely grateful for that. You mention, again, something we've already touched on, but at paragraph 62, it I think was more likely the member services who communicated with local authorities rather than yourselves on a national level. That's right. But that albeit in some circumstances was positive, the picture was very varied across the services. Is that right? It was. I mean, I do know that certainly in the areas of Tayside and Fife, there was very good collaboration there with the councils of I think it was Dundee City, Angus, Fife and Perth and Kinross. They worked very well. The cross-sector working across those 4 local authority areas was excellent, and our services benefited from that. That was everything from food parcels to reaching out to people who were socially isolated, a whole range of other support, and certainly in that area it worked very well. And we've not taken soundings for every service across the country, but certainly in that area I'd have to give praise to those 4 local authority areas who worked very well.
I think you mentioned, without specifically naming various local authorities, but you say at times there were difficulties in receiving information about the commissioning side and funding from some local authorities.
Yes, there may have been that. I think, as I say, there'll be a variety of, throughout the whole pandemic, I guess you had the kind of clear guidance on national level that was there. Then, of course, down to implementation at local authority level would be down to the local authorities. And as I say, from what we can pick up from our services, there was variations in that in terms of how quickly things moved, in terms of, I guess, guidance, help, support, PPE. Again, I'd be hesitant for that to be a criticism, other than if you're dealing with 32 local authorities, they will do things in slightly different ways.
Yes. Later on in your statement at paragraph 80, you talk about the guidance which was issued by your organisation, and I think in preparing that you drew upon and followed various elements, of course, of the Scottish Government guidance, but perhaps tried to tailor that to the services that you were providing.
Yes.
And I wondered how you found that task. How easy or difficult was it?
I guess it was challenging. It was a very good basis that we started from on, in terms of the national guidance we got, the specific guidance for child contact centres. We were also supported in terms of counselling by COSCA, that's the professional body for counselling in Scotland. They provided incredibly helpful, very detailed guidance for how to go about delivering counselling safely through the pandemic, whether that be online or as the process moved back to face-to-face. So again, the advice from COSCA was very useful, and essentially we pulled on the guidance from bodies like those to provide the best advice we could to our services, and then really the training and professional support to our practitioners, that was done by ourselves, and we worked very closely, as we always do, with our 21 services across the country to make sure we're doing that as well as we could.
I wonder if we can conclude by, towards the end of your statement, at the last paragraph, 84, you have been asked whether there are any lessons that can be learned by the inquiry in relation to if another event were to happen which requires the closure or cessation of some of the services that you provide. And you say that the closure of the Scottish court system was really the thing that had the biggest impact for the organisation. And I wondered, what lesson do you think should be learned there?
I don't doubt the challenges involved, but if there was ways for the courts to continue to operate, should anything like that be faced again, that would clearly be very helpful for the families affected and involved in that process. So that's clearly a massive challenge, but that would, from our perspective, be very helpful. I think we could also say just the issue of non-resident parents being able to be in touch with their children during a pandemic is really key. There's clearly a balance to be made there in terms of risk, in terms of infection, but the impact of non-resident parents not seeing their children for such a prolonged time was quite devastating for many people. We're aware many others in different circumstances couldn't see loved ones. You had older people passing away, not seeing their loved ones, but certainly in our context of people who are not living with their children, not being able to see them at all for a prolonged period of time, that felt very harsh and a very big price for them to pay.
I think quite pertinently you say in your statement that sometimes child-parent relationships were already fragile in normal times, and the extended period of no contact just served to weaken the ties between non-resident parents and their children, and has made their future relationships more difficult to re-establish.
That's right, and anything that interrupts that process, that closeness, especially when it's very tenuous to start with, anything that delays or interrupts that process can be very difficult to get back. You know, some of the cases we have, maybe often dads have got a very tenuous and weak link with their child, and if that's missing for 6 months, a year, where it's not developing at crucial stages of their child's development, that can be very difficult to reclaim back.
Thank you. Those were all the questions that I had for you. I wonder if there were any issues which we haven't touched on, which you wanted to raise.
I think the key things we've covered, in particular in terms of lessons for the future, the three I had was about the link between the non-resident parents and their children, the reopening of third sector spaces that were run by the local authorities would be key, and keeping the family courts functioning if at all possible, were something to happen again, they would all be incredibly helpful.
Thank you. Unless there's anything your lordship wants to ask.
No, thank you. That was very helpful indeed, Mr. Valentine. I'm very grateful. Thank you very much indeed.
Thank you.
We're coming back at 1:30, I believe.
Yes.
Very good.
Thank you.